I am the one of the member of the D group. I am one of the member of the D group. Our group, after discussion, prepared the list. Some of the highlights of that our discussion has been taken on this slide. First is the compensation of the victim at different stage of trial. Now, yesterday we have listened the speech of the Home Minister. He is make a submission that the new law is victim friendly law. The victim is considered as a central point of the new law. Now, if this is the position, and the state and the central government and Union of India want to compensate the victim, want to give justice to the victim, then according to me, the lawmaker should consider the sum of points. The first point is the compensation to the victim at every stage of the trial. In the legislature must have to consider the provisions of the Atrocities Act, in which the compensation is provided to the victim of the crime at every stage. The amount is fixed, and at the time of filing of the charge sheet, when the charge sheet is filed, 25% of the amount of the compensation is received to the victim. After framing of the charge, then more 50%, that is total 75% compensation has been paid to the victim. And after judgment of the trial, of the judgment of the case, the 100% amount is prepaid. But I think there should be some restrictions also. We should consider the fact that some persons may take disadvantage of this provisions of law. In such situation, there must be a provision in the law itself to recover the amount of compensation paid to victim if victim turn hostile before the court. I say that it should be there because of the information given by the victim, the law is put in motion, the police agency do the work, APP do the work, and court do the work, and thereafter the judgment is given. The state has to spend amount for everyone. State bears the expenses. States given the compensation to the informant also. And if these facilities are given to the victim, and if she turn hostile, it is a cheating to the state and every machinery of the state. In such situation, there must be a clause of recovering of the compensation provided to the victim. The legislature should also think this aspect that some persons may cheat the state. The law of Supreme Court says that if the accused is also acquitted or discharged, then and then also the victim is entitled for compensation. But that is a different aspect. Finding discharged is that in the investigation officer did not correct the evidence. In such situation, there is proper way to give the compensation. If the acquitter is there, the prosecution fails to prove the guilt beyond doubt. Doubt about the evidence, doubt about the investigation, and doubts in the minds of the judge. So, For that doubt, victim cannot be penalized. But when victim is cheating the court and missionaries, the compensation paid to victim must be recovered, and that should be there in the statute itself. Many times, at many stages, some judges pass the order to recover the paid, the mercenaries will act. The second is, my point is, determination of the amount given to the victim. Now, who is the victim? The Act have defined the victim. But for determining the compensation of the victim, there must be certain evidence on record. For bringing the evidence on record, the IO is expected to do some necessary things. The IO is expected to see the capacity of the accused to pay compensation and the status and the standard in which the victim lives. If the victim is a poor and accused is also poor, in such situation, the compensation should not be a punishment to the dependents of the accused. So, for determining fair compensation, it is necessary for the investigation officer and state to submit necessary information about the earning, social status, educational status of the victim as well as the of accused. Next point, lack of education. Many times the victim does not come in the court to recover the compensation and does not apply for recovery of compensation. They used to approach to the advocates and there they can be harassed. Some amount of compensation can be recovered by the advocates. In such situation, the victim should be educated to approach before DSLA to recover their compensation without any mediation. Thereafter, the compensation which is directed to pay to the victim by the state or as by the accused can be recovered from it. Denial of justice due to delay. This is very much important. As in a recent fact, I came to a case in which a victim was a police party of the village. She helps the police in the investigation. But an atrocities case was filed by her before the police station. No cognizance was taken by the police because of the undue enforce and pressure by some of the authorities. She has applied before the collector, before the state, before the CM, governor, and Human Rights Commission. Thereafter, the direction was given to the concerned police station to register the offence. But there was delay of 2 months. So, though that correspondence made by her was not along with the final report, a police report. So, delay was caused for acquitting the accused. So, there should not be, and the justice is denied to that victim. So, there should be a reasonable explanation to the delay. And for that, all stakeholders should help, and there should be an amendment in the Act that the court can accept the documents tendered by the victim, and it should be considered by the court during the trial. Last is loss of faith, and witnesses can be won over by any means. There are many prosecutors in this institution come today. They all know that why this has been done. The loss of faith is because they did not get justice as they want, as they accepted. as they expected. There is a delay in deciding the matter. So there is loss of faith of the litigants. This is to be considered by the lawmakers, and different steps have been taken. Only by making provision in the law that the charge sheet is submitted within so and so date, charge is to frame on so and so date, matters to be decided on within so and so period, that will not suffice any purpose. As we found that under the Negotiable Instrument Act, the case is to be decided within 6 months. Now, in recent Maharashtra, there is a direction of the Bombay High Court to decide the post-court case within 2 months from the date of filing of the charge sheet, whether it can be really be done, whether the CA report can be received, whether the evidence can be recorded, and the court can give the judgment. Now, the witness friendly consider the mentality of the victim witness and must give friendly atmosphere in the court. For that, the judge is expected to control the advocate of the accused, and that the judge should record the denouement of the witness and victim, and the prosecution should insist the court to record the denouement of the witness if she comes under pressure. Victim must get a protection from every stage of the trial. That is, she must have friendly atmosphere in the police station, before the prosecution, and before the court. Now, the last part is that the previous act and this new amendment act provides copy to be given at free of cost of the police report to the accused. But there is no provision to give copy of the police report to the victim or to the informant. This is very material because the victim or the informant may go through the charge sheet, may consider her evidence, and it will support prosecution to get prepared the informant as early as possible. If the judgment is given, the copy of judgment, the copy of the evidence recorded by the court, and judgment given by the court must be served on the victim at her residential house, so she can file and challenge the order. If this facility order and the atmosphere becomes victim friendly. With this, I conclude my presentation. Dhanyavad.
बैठे बैठे थैंक यू सो मच सर। और अभी हम लोग लंच के बाद रखें कंटिन्यू, क्योंकि लंच तैयार है, तो हम लोग लंच ब्रेक करते हैं और उसके बाद फिर कंटिन्यू रखें। थैंक यू। बाकी हम लोग वापस से ऐसे ही बैठेंगे सर। अच्छा, आप नीचे चलिए, ठीक है, आपका हो, बाकी आ जाएंगे। कोई दिक्कत नहीं सर, आप लंच कर लीजिए फिर लिखवा दीजिएगा, कोई दिक्कत नहीं, लंच कर लीजिए पहले। हाँ, लंच होते ही वापस 2:30 का नहीं, 1 आवर नहीं है, जैसे लंच हो जाता है वैसे आ जाना है। हाँ, 2:30 पर आएंगे फिर नहीं हो पाएगा। जी मैम, जी जी मैम। बी ग्रुप में कौन मैडम थी आपके साथ? ममता, अनिता, शिवानी, सना मैम तो अलग। हाँ। लंबी थी, छोटी थी, छोटी सी ना ममता होंगी। ठीक है। हाँ हाँ, आ जाएगा, अभी है टाइम मेरे पास, 30 मिनट है, कोई दिक्कत। बहुत बढ़िया, बहुत अच्छा, सबसे बढ़िया आप ही का था। बाकी लोग सब वो एक ही फोल्डर बना के दे रहे हैं, अलग अलग भी नहीं दिए, तो मेरे लिए मेहनत बढ़ गई। फिर मैंने भेजा है शिवानी मैम को आपका कि देखो ऐसा बना के दो। हाँ देखो बाकी लोग कैसे भेजे हैं, ये शिवानी मैम का देखो, ये आपका वाला भेजा, मैंने कहा ऐसा बना के दो, ऐसा होता तो बेहतर होता। ठीक है, इन्होंने कैसे भेजा है, एक ही फोल्डर भेज दिया है, उसी में सारे पांचों पीपीटी हैं। देखें ये 6 एनसीपी ग्रुप 1, इसी में पांचों हैं। अब मैं कहाँ से निकाल के निकालूं, वो भी पीडीएफ आप भेजा, पहले पीडीएफ भी नहीं दिए। चलिए कोई बात नहीं। सर क्या मैम, क्या सर?
रजिस्ट्रेशन करा रहे
हाँ हाँ
हैं, जो ट्रेनिंग नेम है
हाँ,
वही हमारा जब लॉगिन करेंगे।
लॉगिन आईडी आपका 12345 तो पासवर्ड होगा, और आपका नाम शायद आपका आईडी होगा। हाँ वही रहता है। हाँ बिल्कुल, नहीं तो फिर मुश्किल हो जाएगा। बिल्कुल अनाउंसमेंट हम लोग करेंगे अभी शुरू होती ही। अरे मैं पहले ये तो कर लूँ काम, मैं आ रहा हूँ थोड़ी देर में। नहीं नहीं कोई इशू नहीं, मैं कर लूँगा। सर अब क्या करें, जिम्मेदारी है ना, जिम्मेदारी है तो करना ही होगा।
सर क्या क्या करना है मुझे बता दीजिए, मैं कर
हमने 5 टॉपिक के 5 फोल्डर बनाया,
ठीक है सर।
तो उसी में ग्रुप वाइज हमको अपना प्रेजेंटेशन डालना है। जैसे आपका ग्रुप डी का सबसे पहले आया, मैंने वो डाल दिया। अभी ये सेकंड ममता मैडम का मैं डाल रहा हूँ, ममता नहीं अनीता मैडम का। ठीक है, अनीता मैडम का कौन सा ग्रुप था?
अनीता मैम का ग्रुप सी है सर।
पक्का?
हाँ सर, क्योंकि पापा के साथ बैठी थी वो रूम नंबर 33 में।
ठीक है।